morning, everyone. I can't actually see anyone because those lights are so bright. This is great. Thanks for coming out on the morning of day 3. This morning we're going to talk about, with great power, as Steve said, comes great responsibility, mobile development and the law. So why am I here? Who am I? Well, I created my first website in 1997 on my university's dial-up Unix system using the Lynx text browser, which tells you how long I've been doing this. I was a professional full-time web designer from 2007 to 2015. But throughout all my work on the web, I took a really keen interest in digital law and policy, issues that affect our work, such as privacy, copyright, accessibility, e-commerce, that sort of thing. And 2 years ago, I pivoted altogether, and now I only focus on digital law and policy. But I recently did a conference talk, and the organizers came up with this really great description of me that I wanted to hug them for, because it felt like for the first time somebody actually understands what I do. And what they said is, I spend my work time trying to bridge the gap between policymakers who create digital regulations and the digital professionals, that means you, whose work on the web is impacted by such policies. The things you do online, from sending messages to friends to starting a new business, are impacted by the decisions of people at local, regional, and global levels. Understanding current laws and pending regulations can help inform how you do, what you can do with your data, how to do right by your users, and what you need to say to your local representatives. So that's what I'm here to do for you this morning, though I will caution you that I am not a lawyer, and none of what we're going to discuss this morning should be taken as legal advice. So the first thing you're probably thinking is, why am I here? I'm a developer. I'm not a lawyer. I've got a team for that. How is knowing privacy law my job? Well, I'm here to help you understand this morning that yes, it is your job. As developers, it's important for you to have a working knowledge of the policies and frameworks that constrain and shape your work, particularly at this time in our very confused political history. There's other reasons why it is your job to know privacy. One example is a colleague of mine, Danny Dagan, came up with this, and I keep stealing it from him, but Jenny from marketing. This is when Jenny from marketing knocks on the door of your office and says, hey, I want you to add all of these fields to the contact form and collect all of this data about the people using our app. And you're thinking, can we do that? No, really, can we do that? Is that legal? Is that allowed? Shouldn't we be asking permission? And Jenny doesn't know, because Jenny's just come up with this great idea, and if she doesn't know that this might not be legal, who's going to tell her? That is your job. Another reason you need to start thinking about it as your job is what I call Prosecco planning. And I think we've all experienced this. This is when a client gets together with some friends on a weekend and has some Prosecco and phones you up with a fantastic business idea that they want you to get started with on Monday morning, building their app. And you're thinking, I don't know that that's entirely legal, but they're convinced it's a great business idea because they're full of Prosecco. This has actually happened to me. So you get started on it, and then you don't hear from them for 3 months because they forgot all about it because they were drunk. But anyway. Again, it is your job to raise those objections if they have no idea that that's it. Final reason why privacy is your job, these guys. Steve first contacted me about this talk in, I think it was October. And if I had done this talk in October, it would have been a completely different talk to you, because in October we were heading for a Clinton presidency and a soft Brexit. I'm still trying to wrap my head around what we're heading into right now. But credit where credit is due, these two individuals, who shall remain nameless, have done more over the past 6 months to get people thinking about privacy and how it impacts them and their work than any amount of standing up here and bleeding I could have done for years and years. So that's why today we're going to work on changing your mindset from privacy as being this thing that your lawyers deal with to something that you need to start really thinking about. So privacy is governed by data protection law, and it's always helpful to go back to the absolute basics and explain what is data protection. It's one of those terms we use all the time without really understanding or thinking about what it means. And I like this quote from a lobbying and privacy group called Privacy International about what is data protection. And here's what they say. Data protection is commonly defined as the law designed to protect your personal information, which is collected, processed, and stored by automated means or intended to be part of a filing system. In modern societies, to empower us to control our information and to protect us from abuses, it is essential that data protection laws restrain and shape the activities of companies and governments. These institutions have shown repeatedly that unless rules restrict their actions, they will endeavor to collect it all, mine it all, keep it all, while telling us nothing at all. Data protection is about safeguarding our fundamental right to privacy, which is enshrined in international and regional laws and conventions. And I really like that quote because it gets to the heart of what I want to talk with you next, which is that quote about it's a fundamental right enshrined in law. It isn't for everyone. Different cultures have different approaches to privacy. In the UK and Europe, where we are for now, privacy and data protection are enshrined in law as fundamental human rights. Non-negotiable, it's like the right to breathe air and drink water. They're fundamental human rights because we had a pretty brutal 20th century in Europe. We had genocides against people for who they were. Data protection law is a response to that. We have one overarching data protection law across all of Europe that covers all member states, all sectors, all uses of data, whether you're a gigantic hospital, a one-woman app development studio, or anything in between. European data protection law is not tied to citizenship or nationality. If the data is processed and dealt with within Europe, this law applies. If you are an American accessing the Code mobile app in this room right now, you're covered by European data protection law. And over here we have a culture of constructive cooperation before litigation. You don't really see a lot of I'm going to sue you and it ends up in a big court case. The US is quite different. In the US, free speech is the fundamental human right, not privacy. And in fact, privacy is often seen and even specifically mentioned in legal suits as an impediment, or privacy is seen as an impediment to free speech. Data is seen as a commodity which is to be bought and sold. There is no one overarching data protection law for the United States. There is a piecemeal approach across sectors such as HIPAA for health information, COPPA for information concerning children, and by states, California has a data privacy law, other states don't. US privacy law is very much tied to citizenship and nationality, which is why you have American developers kicking off about why do I have to follow European data protection law? I'm in America. But anyway. And the US has the culture of sue first, ask questions later. It's contentious, it's litigious. I can't talk this morning, this campus is full of hay fever. So it's helpful also to understand what we're talking about when we talk about data. Under European data protection law, personal data is data about a living individual who can be identified from the data or from any other information added to the data. Your name and your email address are a personal data record. If you were in Jonathan's talk yesterday about Firebase Analytics and Google Analytics, all of that is personal data. Every single record you're accessing brings with it data protection compliance obligations. A data controller is a person, a business or an organization, who either alone or jointly in common with others determines the purposes for which and the manner in which any personal data are or are to be processed. A data processor is any person other than an employee of the data controller who processes the data on behalf of the data controller. So when Jonathan's looking at user analytics, he's being a data processor. When you are collecting analytics, you're being a data controller and you're being a data processor. So it's important to start thinking how you actually fit into this very complicated framework of data protection law. We're here at a mobile development conference, so how does location data specifically fit into this framework? In the UK and Europe, again, we have one single data protection law covering everything. Every European member state has a data protection regulator who you are legally accountable to in your work with location data. Here in the UK, that's the Information Commissioner's Office, or ICO. Location data counts as personal data under European data protection law. So don't think you're not included here. You are absolutely included, and you are accountable to a regulator for what you do. And the point to make is location data never stands on its own. It's always mixed with other data, some of which is sensitive. Sensitive data is any data pertaining to health, sexual preference, criminal convictions, trade union membership, religion. So you actually may be collecting a lot more data than you realize. And sensitive data carries even stricter requirements than your day-to-day location data. That's Europe. In the US, again, there's no one single data protection law. It's piecemeal by state and sector, and there's no central regulator. So you actually have a much bigger headache trying to figure out what your legal obligations are in the US. We have an administration which is very much influenced by market ideology over law. What little privacy legislation there is in America, they're trying to gut and get rid of it and turn it over to the market. We all know how well that works. For what location data law there is in the US, it's governed by the Electronic Communications Privacy Act of 1986 and the Communications Act of, does anyone know the year? This is staggering. 1934. It's actually a law dealing with radio signals. There have been 3 pending pieces of legislation on location data, which have been kicking around in committees since 2011 and 2013, respectively. And if they went nowhere under the Obama administration, good luck seeing anything happen to them under the Trump administration. So if you work in the US or have US customers, you have an obligation to educate yourself on this absolute mess of privacy and location data law, or lack thereof, that governs your work. But why am I here today? Why have I been asked to come here? That's because EU privacy law is changing, and it's changing big time. Meet GDPR. GDPR was going to be my entire year. Thank you very much, Donald and Teresa. GDPR is the General Data Protection Regulation. This replaces the 1995 Data Protection Regulation, which has governed Europe. It's really quite staggering to think that we have done everything we have ever done in our industry using a data protection law from 1995, from the dial-up and floppy disk era. As before, it will be one rule for all of Europe, regardless of use or sector or situation. In the UK, we know this as the Data Protection Act. This will replace the Data Protection Act, and I know what you're thinking, and we'll get to that in a minute. This becomes enforceable on the 25th of May, 2018. That's your deadline day. It's going to come around fast. You need to start now. I'm not saying that to scare you, but I do this for a living, and it's taken me a year as someone who lives and breathes this to really feel comfortable with everything I know about it. Start now. In addition to GDPR, we have the ePrivacy Directive, which is the regulation concerning respect for private life and the protection of personal data in electronic communications. This is another data protection and privacy law, which is also being overhauled. And the way it's been overhauled is it's now being done as a sort of companion law to GDPR. Think of these 2 laws as a double helix which wind together. The ePrivacy Directive deals with communications metadata, e-marketing mailing lists, device fingerprinting, which is where all of you come in, and cookies. Yes, this is the cookie law. This is changing too. It's got new rules on tracking and location data, including strict opt-in consent for everything, which is the fundamental principle of GDPR. We'll get to that. Everything has to be opt-in consent. This law isn't quite done yet. It's still in draft form and subject to tweaking, so I don't want to get into it too much because that would just be doing the whole thing. But whatever final form it takes, it also comes into effect on 25th of May, 2018. So you have got just over a year to get to grips with a complete legislative overhaul of the rules that govern your mobile app development. Yeah, I know what you're thinking. What does Brexit mean? Right. One of the fundamental principles of European data protection law is called extraterritoriality. As I said at the beginning, it's not tied to citizenship or nationality. European data protection law concerns the people in Europe that the data is being collected and processed about. That means that if you are still doing business in Europe after Brexit, whether it's with a customer on your app, the people using your app, or the customers you're developing the apps for, you are still beholden to European data protection law regardless. It doesn't matter that the UK isn't in Europe anymore. You're collecting and processing data on European citizens, so you still have obligations to that law. Fundamental principle of European data protection law as well is that any non-EU third-party country that you're doing business with has to have a data protection system in place which is deemed equal to and adequate with European data protection law. And this is where the absurdity of Brexit really becomes clear. Why are we going to leave a system that then requires us to reconstruct that law on its entirety under a different name? So that is what's happening with GDPR after Brexit. We are going into it regardless. The UK government has confirmed that, and they're going all in. So you need to prepare and comply for GDPR as if Brexit was never happening, because we're going into it regardless. And once you're there, do not budge. There have been a couple of surveys over the past month, and these are usually sort of the software developers running these surveys, so take them with a grain of salt. But they're saying that something like 25 to 30% of UK businesses are planning to quit their GDPR compliance because they think it won't apply after Brexit, which is completely bloody insane. We are going into GDPR, and you're still beholden to it. So get into GDPR, and once you're there, don't say, hey, we're out of Europe now. We don't have to do this anymore. Don't budge. Here's why. We don't know what's going to happen down the road, 2020-ish. We don't know if anti-European spite will be allowed to overrule common sense, and they pull us out of GDPR, which overnight renders it impossible to do business with anyone in Europe. We also are currently living under the most anti-privacy, pro-surveillance political administration ever to exist during peacetime. Is the government that came up with the Investigatory Powers Act and necessary hashtags going to try to move us to a US-style, market-driven, self-regulatory system, which is where basically people say, yeah, we're going to respect privacy, with their fingers behind their back. This is why I said at the beginning, privacy is your job, and why it's so important to get to grips with the law and stay there. Because after Brexit, you may have a better handle on how to protect your users' privacy than the actual law they may or may not put in. Incidentally, I've got a separate side blog where I'm monitoring specific legal developments on laws that affect our work throughout Brexit, which you can bookmark. It's really quite boring, but I enjoy it. It's digitalbrexit.wordpress.com. So how do we move you towards developing a healthy privacy framework for your studio or for your business or for your obligations? It's important to understand that there is no one template or defined path through GDPR. You can't checklist your way out of this. It's hard work, and it requires a lot of thinking. And this talk this morning is in no means a comprehensive introduction to GDPR. That would take a whole 3 days, and you would be jumping into the canal by day 2. But what I want to go through this morning is just some of what GDPR requires that specifically impacts your work as mobile app developers. What does GDPR require of you? Does everyone know what PBD means? Does nobody know what PBD means? You probably heard of it as privacy by design, which is implementing privacy from the start into your workflows. I can't believe that none of you knew that. GDPR is a little bit different. GDPR requires privacy by default. It's taking those PBD principles and taking them a bit further. PBD means you must build in maximum data privacy from the start. At your app's initial design stage, no more getting drunk on Prosecco and jotting something on a napkin. Throughout its life cycle, throughout the user's engagement with your app, after the user's engagement has ended, so after they close their account with you, and after your app is mothballed. What are you doing with all that data? You're going to have to do privacy impact assessments, which again is, there's not a single defined template or path through it, but this is the process by which you sit down before you have written a single line of code and work through all of these questions and all of these issues about how you will build in maximum data privacy from day one. And that document becomes legally accountable. If something happens and the data protection regulator wants to know what sort of PIA did you do, what sort of PBD principles did you build in, you've got to produce that document and give that to them. And there's a new information commissioner in town, and she's a new sheriff in town, and boy, I wouldn't want to annoy her. Part of privacy by default is about data collection, minimization, and data retention. Collect and retain as little data as is required. Don't make every single field mandatory. Don't capture information that is not absolutely essential to what your app needs. All of the information you collect must have a legal or valid commercial justification under GDPR. And there's actually a table. You can't just pull an excuse out of the air, say, yeah, we might need that bit of data. You've got to be able to cite it against data protection law. And all of the data you collect and process must have the user's clear opt-in consent. No, just the fact that I've downloaded this app means I consent to you collecting my data. No more, I'm giving you permission to collect this so you can also collect this. It becomes a lot more granular. Everything has to have opt-in consent. That data must be retained for as little time as is required. You need to come up with a data retention and deletion schedule. You must delete it when it is no longer necessary. And again, this has to be on a schedule that goes into a document that you could produce. You can't just pull something out of the air. If you're keeping, I had a step counter app that tracked the geolocation data of all my steps. Why is that necessary? Why do I need to go back 3 years later and find out where I was in Tesco 3 years ago? There is no legal or commercial justification for that. So that's the sort of issues you have to think about. And again, all of these processes, all of the decisions that go into how you do this, and everything you actually put into the code has to be documented. Audit and document the heck out of everything. Your apps, your contact forms, the third-party data that you're mixing in with your location data, everything. It's all got to be documented and processed. You actually should be documenting all of this anyway, but GDPR is going to pull your socks up big time. A big part of GDPR is greater user rights. Under GDPR, the data about a user belongs to the user, not to you. The user has the right to be informed about what data you're collecting and what you're doing with it. And that's done through privacy notices, which we'll talk about shortly. They have a right to access the data you are keeping on them. You've heard these stories of people who contact Facebook to see what sort of data do you hold on me, and they literally get an 800-page printout in the mail. You've got to be able to do that. You have to be able to produce a copy of all of the data that you hold about an individual. The user has the right to rectify incorrect information. If the computer says no, they have a right to ask why, and if the computer says no because something on their file is wrong, they have the right to get that fixed. They have the right to remove certain personally identifiable information This is the much misunderstood right to be forgotten. It's not a tool of censorship. It's not a tool of shutting down discussions about you that you don't like. It's a tool by which certain identification that does not need to be in the public domain can be removed from the public domain. They have the right to restrict data processing. That means they have the right to ask you to stop using their data for whatever it is you're using it for. Portability is a new thing under GDPR. Under certain circumstances, they have the right to take their data off of you and take it somewhere else. Think of things like online banking. Say you want to switch bank. You should have the right to download all your financial transactions in some form or other and just upload them to another app. Lots of us are bloggers. We've all seen that debate about who owns your content. You should be able to download all your content off a blogging platform and then upload it somewhere else. Oh, and the user has the right to object to processing, which goes beyond restricting it. They have the right to tell you to stop and stop using it just in the general sense, not just for themselves. They also have the right, if you work in advertising or profiling, to object to automated decision-making and profiling. And a lot of you will actually be involved in this as mobile app developers. If the data you collect and process and share is used to create profiles of people in the background, such as the ones that advertisers and marketing use, they have the right to object to this. This is all the shadow profiles that exist of us somewhere in the ether, combined with all sorts of data records. GDPR is going to try to crack down on that. And the way a user accesses all of this information is called a subject access request. You should be prepared to respond to the rights they already have under the current data protection law anyway. But under GDPR, if a user contacts you saying, I want to see all the data you're keeping on me, or I want you to stop doing this, you have a legal obligation to respond to that request in a certain amount of time, which is defined by law. And someone once asked me, can you charge them for this? Because this is going to take a lot of our time. No, you absolutely cannot charge for a subject access request because privacy is a fundamental human right. You cannot charge people a fee for exercising their human rights. We talked about the right to be informed, privacy notices. The days of privacy statements that are 30 pages of legalese written by a lawyer are done. Your apps, your websites, everything you use must now have a privacy notice that indicates all sorts of things, but among them, what data you're collecting, why you're collecting it, as in the legal basis, what third parties you are sharing it with. We've all accepted terms and conditions that say we may aggregate data with you about third parties. Now you have to list them. You actually have to say who they are. There was a tweet going around the other day that was PayPal. Like they've updated their page. Here are the 600 third parties we may share information about you with. And everyone was looking at it like, oh, I can't believe that. But those of us who work on GDPR said, yeah, that's GDPR compliance. It's everything coming out into the open. The fact that PayPal is sharing your data with 600 third parties is not new, but now you can see it. You have to say in your privacy notices what third-party data you're aggregating it with and where that data comes from. Where are you getting all of that information from? List that. You have to talk about your data retention and deletion policies. How long are you keeping it? Why? When do you delete it? How can a user get in touch to confirm that you've deleted their data? And you also have to provide information on their subject access rights. Oh, also, if any information you're collecting is intrinsic to a contract, you have to provide that information anyway. And everything here has to be in clear, simple, plain English. No more legalese gobbledygook, and no more using doublespeak to kind of cover up what you're really up to. In fact, I didn't get into this particular provision of GDPR for this talk, but if you make an app targeting children, the privacy notice has to be written in language that a child can understand. So that's going to be a fun challenge. Incidentally, if you make apps for children, I saw the BBC presentation yesterday. You need to look into GDPR because the rules on apps targeting children they have seriously been tightened up. Under GDPR, again, privacy by default, data protection by default, technical and security accountability gets real. Everything must be documented. All of your technical and security measures must be documented. Again, you should be doing that anyway. Now, I know a lot of you come from large organizations that have armies of lawyers and armies of security staff, but some of you might be self-employed. It might just be the two of you. You don't have that sort of backup infrastructure. So it's even more important for you to start thinking about your technical and security measures and documenting them, because under GDPR, the technical and security measures that you take in your business are part of your data protection compliance. If there is a data breach, they're not just going to ask you what contact forms do you have and where is that data stored. They're going to ask you if you hashed and salted your passwords. Can you sandbox data? Are you walling it off from others? Do you ship automated background security updates to your app? Do you have a responsible disclosure program? Are all of your staff trained on data protection? And that doesn't just mean the coders, that means the reception. For when someone phones up the receptionist and does some social engineering. The physical data security. Who is accessing this? Do you have a warning on your system that pops up a flag if someone tries to access a level of data they're not authorized to access? Are you encrypting all of your data at rest and at transit? So, oh yes, and this is why this is all important. Mandatory data breach notifications to your data protection regulator, which is ICO. That's a big part of GDPR. And I believe it's within 72 hours. We all heard about Yahoo taking 6 months to inform the regulator that 500 million accounts had been breached. I don't even remember the figure that they would have gotten as a fine for that under GDPR, but it was approaching the hundreds of millions. So again, if a data breach happens and the very crotchety data protection commissioner gets in touch with you, she's going to want to see a document confirming all of the technical and security regulations, rules, restrictions you had put into your app before this data breach had happened. I've put a link to a document there which you can read on the journey home. It's really, really good. It's ICO's Guide to Data Protection for Online and Apps, and it's basically a collection of all of the horror stories that they've looked into from people who screwed up. Why did people have data breaches? Here's what they didn't do. These slides will be up at the end, of course, but it's a really good document, and it's written for developers, so have a look at it. That's been a sort of whistle-stop overview of GDPR. But as I said at the beginning, don't constrain yourself to it. Don't think we're compliant and that's it. You need to use it as a starting point. So how do you go beyond European data protection law? Privacy Shield. Privacy Shield is technically part of GDPR, but a little bit aside from it. Remember we talked about how any third-party non-EU country has to certify that they have a level of data protection compliance equal and equivalent to European data protection law in order to do business with Europe. Because so many of these companies are in America, they came up with this agreement called Privacy Shield, which is a voluntary agreement, voluntary system run by the US Department of Commerce, whereas American companies doing business with Europe can self-certify compliance with EU standards for the EU data that they're processing. There's a lot of political contention about Privacy Shield, and I was certainly very vocal about its predecessor. It's fragile, it's imperfect, it's not great, and it may not survive 2017. But for now, it's in place, and it provides you with legal certainty. So you need to ensure that any US companies you're doing business with are Privacy Shield compliant. You should probably get into Privacy Shield yourself. You need to ensure that any American third parties you're doing business with, whether that's your analytics, your advertising, whatever, are Privacy Shield compliant. And you need to get this in your contracts. Because it's all well and good for you to do everything you have to do under GDPR. But if you're sending data to a third party that then has a data breach, that can backfire on you. So you need to protect yourself in your contracts. Beyond GDPR, you can think about doing things like granular privacy options. Give people choices, not binary yeses and nos. A user should be able to turn off location-based services at will. It shouldn't be collecting data about them on an app that is not running. I had an app from a coffee chain up in Glasgow, and it was find your nearest shop, but it was on running all the time. What is it doing with that data? Why does it need to know where I am if I am nowhere near a coffee shop and not even looking at it? A user should also be able to geofence areas from location-based services. I don't need to know where someone's home is. I don't want to know what they're at home. This is really basic, but again, don't require location data if it's not needed. Don't collect location data if it's not needed. Don't require location data for non-location services. There was a privacy journalist going apoplectic on Twitter about 2 months ago because she went to update an app and she couldn't because the Google Play Store was requiring her to turn on motion tracking so she could update an app. Now that was a bug, which they acknowledged. But that's just the height of the ridiculousness. Why does the App Store require location tracking and motion tracking to update an app? It's ridiculous. And don't be Uber. That's my slide for the rest of 27. What I mean by that is you saw the thing in the autumn where it was revealed that they were tracking people's data after the journey had ended. So there's absolutely no reason they should be tracking your data once you're out of that car. But they were tracking it for another 5 minutes to see where you went after that. And this was supposedly to, improve the quality of their service, which is nonsense. And when I say don't be Uber, what I mean by that is don't do that in the first place. Don't leave it for some it so that it only goes out through Facebook and Twitter and the blogosphere. And don't leave it to people to find things out and then have to Google clickbaity articles like Uber's tracking your location, 5 simple ways to stop it. They should have taken ownership of that, and they shouldn't have done it in the first place. So don't do really daft things like that. They're just going to make you look bad that you shouldn't have done anyway. Mandatory social sharing and social logins so that you have to share everything you're doing on an app or you have to log in using a social media service. Don't. Seriously, just don't. Don't. There is no valid reason why anyone should have to give all of their information to any social media service to use a simple app. Give them an option to set up an account separately. I'm sorry if that creates a little work for you, but requiring a social login is not going to pass the PBD test under GDPR. So what can you do now that you know a little bit about the legal and the policy framework to sort of encourage a culture of privacy first within your workplace and your studio? Well, best thing I can advise is change your mindset. Don't think that, oh, privacy is law and it's a law we have to comply with. Privacy is actually doing right by your users. Compliance is a thing we have to do so we don't get a fine, and God knows there's already so much of that going around with GDPR. Comply or you will get a fine. That's not why you should be looking to comply. Compliance is an opportunity to get it right and do it better. Change out of thinking that the data you hold is a commodity, because right now the data you hold is a liability. It's a liability under the law, and hey, we're living under the Investigatory Powers Act. Theresa May has all the data that you do, and so does Donald Trump. I have lost count of how many people have approached me for GDPR help, and then they say, you know what, actually, we're probably okay with what we've already got. No, you're not. No, you're not. You've got to rip up everything and comply from scratch, but think of it as a positive business process. And you're probably thinking, oh God, we can't afford the lawyers to do this. You don't actually have to have lawyers involved to get started on improving your privacy. There are probably really advanced, specific contractual issues you'll want to bring your lawyer in on. And there's also the matter under GDPR of having to appoint a data protection officer, which is a person within your organization who has legal accountability for your GDPR compliance. But that person does not have to be a lawyer. And I'm happy to talk more with you about that afterwards. So here's just some ideas of what you can do to become a privacy champion within your workplace. Audit everything. Audit your processes, your systems, your workflows. Document everything. What data do you have? Where do you keep it? Who has access to it? What do you do with it? Integrate PBD and DPBD into everything you do. Just make it a part of your normal workflow. Train everyone in your organization on responsible DP and privacy practice. It's not your lawyer's job. It's everyone's job. Refresh everything regularly. Don't be one of those studios that thinks, yeah, we complied 2 years ago, we're fine. You're not. Document everything regularly. Every time an employee leaves, every time an employee comes in, train them up, document it, refresh everyone. Check your contracts. Who are you doing business with? What are they doing with the data you're sending them? Prosecco planning. Challenge colleagues and managers who ask you to engage in excessive or illegal DP practices. Because if you don't do it, no one else will. Make the privacy of your apps your selling point and use it. People care about privacy now. It's getting real for them. That's the best thing that you can sell to your audience, privacy. Keep up with changing UK, EU, and data protection developments, whether that's GDPR, the ePrivacy Directive, or I don't even want to think about what's coming up. And as I said, use privacy law as your starting point, not the end. So thank you all so much for listening. Steve, do we have time for questions? We do. Cool. Thank you.